So, distinguished participants, friends and colleagues, welcome to the closing conference, Giving Hopes to Girl Children in Armed Conflict, a joint commitment from the academic community. I could not attend the opening conference Monday, so the organizers gave me the task to introduce this second and closing conference. I'm deeply pleased and honored to open this conference, organized, as you know, by the Committee of the University's Network for Children in Armed Conflict, the first network entirely dedicated to the issue of children involved in situations of armed conflict. The network, which comprises at the time 38 partners, among them the universities of Perugia, the Istituto di Sanremo, and the University Sapienza of Rome, on behalf of which I'm speaking today, was created a few months ago, the network for raising awareness on the urgency to take actions for tackling the involvement of children in armed conflicts. The universities I mentioned as part of the parties of the network are from 20 countries across Europe, Middle East, Africa, North and South America, and it is still growing. The initiative has benefited from the support of the Italian Ministry of Foreign Affairs and International Cooperation, as well as the endorsement of the Special Representative of the United Nations Secretary General for Children and Armed Conflict, Virginia Gamba, who has kindly sent a statement on the occasion of the opening ceremony last Monday. So it's a key priority both for the Italian government and the United Nations. My university, Sapienza of Rome, has joined with enthusiasm the network with true conviction that the academic community could play and should play an important role in the promotion of this topic, in the promotion of the cause of children's rights, with a specific attention to the situations of crisis and armed conflict. This is a year of anniversary. All of us know very well that we have the anniversary, 31st anniversary of the Convention on the Rights of the Child, adopted in November 1989, as the cornerstone of the protection of child rights at the international level. And it is also the anniversary of the 20th anniversary of the optional protocol to the Convention on the Rights of the Child and the Involvement of Children in Armed Conflict, adopted on 25 May 2000 and entered into force 12 February 2002. A protocol that has a high number of ratification. 170 states have in fact already ratified it. Nonetheless, notwithstanding the existing of these legal instruments, the number of children involved in armed conflict is unfortunately increasing. This issue constitutes a global concern, as on many occasions the UN Secretary General Antonio Guterres has pointed out. According to the report of the Office of the Special Representative Gamba on this issue of May 2020, last year over 25,000 children were involved in armed conflicts, and many of them are victims of 6 grave violations identified by the United Nations, as to say killing and maiming of children, recruitment or use of children as soldiers, sexual violence against children, abduction of children, attacks against children, against school and hospitals, denial of humanitarian access for children. In this context, the implementation of the existing international legal instruments and particularly of the optional protocol is crucial. So we will today address some of these issues in the two roundtables in which the conference is structured. The first one is dedicated to strengthening the judicial protection of girl children affected by armed conflict, and the second one on strengthening the implementation of the UN Security Council Resolution 1325/2000 on women, peace and security in order to protect girl children in armed conflict. The last part, we will have some conclusions and the indication for future guidelines to be adopted by the network. I really thank you very helpful for your being with us today, and I pass the floor now to Professor Fausto Pocar, who will be leading the first roundtable. Thank you very much. Professor Fausto Pocar, you have the floor.
Thank you, Professor Marchisio, for giving me the floor. I have to tasked with moderating the first panel, as mentioned by Professor Marchisio, on strengthening judicial protection of girl children affected by armed conflicts. Now, we do this it has been recalled on the anniversary of the optional protocol that was adopted in 2000. But let me mention another document that has not been mentioned during this conference, not even on Monday, but it is quite important in our work, and that's the African Charter of the Rights and Welfare of the Child, which was adopted in 1990, and now is exactly the 30th anniversary of that document, where it echoes the provisions of Article 38 of the convention adopted in 89, but it's particularly important that it stresses these obligations of states in a document specifically concerned with children. Now, on the judicial protection, this is clearly an important topic in protecting children, as well as protecting individuals in general. Let me recall that a special protection for children was declared in important documents of international humanitarian law, in particular in the optional protocols of 1977 to the Geneva Conventions of 1949. Article 77 of the first optional protocol and Article 4 of the second protocol concerning, respectively, international and non-international armed conflicts, refer to the special protection of children, and also, of course, to prohibition of using minors in conflicts as soldiers. The convention also repeats this question of the special protection, and so does the African Charter I just mentioned. More in general, access to courts for the protection of rights is a basic principle of human rights. And it's clear that children must have access to courts to protect their rights, and be it in situation, normal situation, and in situation of armed conflicts. There is also the problem of the protection that may derive from criminal jurisdiction, from the prosecution of those who commit crimes against children, in particular, for what we are concerned here, crimes against girl children. And it has to be recalled here that these crimes are war crimes under international law. We have a very distinguished panel here to discuss these problems of the judicial protection, and a panel that includes first Judge Guido Raimondi, who is president of section of the Italian Court of Cassation and was formerly president of the European Court of Human Rights. We have Professor Raffaele Cadin of the Sapienza University in Rome. We have Professor May Al-Hamari of the Middle Technical University of Baghdad in Iraq. We have Professor Dragos Cilea and Dr. Madalina Botina of the University of Târgu Mureș in Romania. And we have Professor Silvia Scarpa of the John Cabot University of Rome. Now, I will give the floor to them in order to have their perspective. And let me first give the floor to Judge Raimondi and ask him what kind of protection for girl children has been given or is available in the jurisprudence, in the law and the jurisprudence of the European Court of Human Rights. You have the floor, Guido.
There's no, do you hear me? Now it's working, apparently. It's working, yes, but I don't hear Professor Pocaro. I understand that I'm heard. So thank you very much to the organizers. Thank you, Mr. Chairman, dear Fausto. I greet Professor Marchisio and all the participants. And so I was saying that I'm supposed to intervene from the point of view of the court in Strasbourg because of my past experience in that context. And we are not finished with anniversaries because today, this year, 2020, is the 70th anniversary of the signature of the European Convention on Human Rights. And in fact, speaking about judicial protection, the Strasbourg Court is well known as the sort of champion of judicial protection. Article 6 of the European Convention on Human Rights on access to justice and fair trial is absolutely central in the context of the European system for the protection of human rights. In a mechanism based on subsidiarity, the convention simply could not work if domestic judges did not efficiently protect fundamental rights at home. Furthermore, the case law in the Strasbourg Court stressed that the convention could operate exclusively in a democratic environment, i.e. in countries where democracy is effective, and there is no effective democracy without an independent and impartial judiciary, a concept which is now affirmed in force also by the Court of Justice of the EU. And I refer, of course, to the important judgments of the Luxembourg Court adopted in 2019 concerning, in particular, the reforms in Polish judiciary. And the situations we are considering in this conference would clearly need strong judicial protection. Professor Marchisio has listed the possible harms to children in armed conflict identified by the United Nations: killing or maiming, using, recruiting, conscripting, or enlisting in armed forces, and so on and so forth. I will not repeat that list. And the least that can be said is that, given the context in which in most cases, these situations occur, expecting strong judicial protection might be simply an illusion. Of course, children in armed conflicts is a global concern, and the Strasbourg Court is a regional institution. There are obviously, for these reasons, clear limits to its action, even though the more and more one can witness a growing attention to its case law from important judicial actors located outside Europe. Recent examples are the consideration for the jurisprudence of the Strasbourg Court by the Japanese Supreme Court concerning the protection of children born out of wedlock, and by the Indian Supreme Court about the criminal suppression of homosexuality. In fact, interest for the Strasbourg Court has been expressed exactly from one of the areas of the world where the phenomenon we are considering today has been more acute. I refer to the Colombian internal conflict between the government forces and FARC. In a study of 2006, a number of tragic harms to children involved in that conflict are reported, such as young girls who gave themselves or were given by their families to paramilitary forces in order to try stave off violence against their families, abduction or rape of girls as young as 5 years old by armed opposition groups and paramilitaries as part of efforts to destabilize and terrorize communities, and so on and so forth. Well, when considering the need to implement post-war justice, in particular transitional justice, in the framework of the negotiations for the peace agreement between the Colombian government and FARC, both parties decided to entrust the President of the European Court of Human Rights with the delicate task of appointing one of the 5 members of the Commission, which was supposed to select the members of the relevant judicial bodies. When the agreement was finalized in 2016, I appointed Alvaro Gil Robles, a well-known Spanish political figure, former Commissioner of Human Rights of the Council of Europe. And this was a way of indirect involvement of the Strasbourg Court in the judicial protection of the victims of the armed conflict, including girl children. The Strasbourg Court has also been directly involved in the judicial protection of girl children affected by armed conflict. In fact, the scourge of armed conflicts does not spare Europe. The most recent interstate cases brought to Strasbourg, I refer to Armenia versus Azerbaijan and Armenia versus Turkey, concern the hostilities in Nagorno-Karabakh. And one may consider that, at least from a given point of view, this is also the case of the armed confrontation between the Turkish government and the Kurdistan Workers' Party, PKK, in the eastern part of the country. In this framework, it is worth to note the case of Aydin versus Turkey, a judgment of 25 September 1997. In this case, the applicant, a young Turkish woman of Kurdish origin, aged 17 at the relevant time, was arrested without explanation and taken, along with 2 other members of her family, into custody. She was blindfolded, beaten, stripped naked, placed in a tie and hosed with pressurized water before being raped by a member of the security forces, and then again beaten for about an hour by several people. A subsequent medical examination by a doctor who had never before dealt with the rape case found her hymen torn and widespread bruising on her thighs. The applicant further claimed that the family was intimidated and harassed by the authorities to coerce them into withdrawing their complaint before the European Court of Human Rights. The court stressed that rape of a detainee by an official of the state must be considered to be an especially grave and abhorrent form of ill treatment, given the ease with which the offender can exploit the vulnerability and weak resistance of his victim, especially when considering we are confronted here with a minor. Furthermore, Rape leaves deep psychological scars on the victim, which do not respond to the passage of time as quickly as other forms of physical and mental violence. This experience would have left the applicant feeling debased and violated both physically and emotionally. And the court found that both the accumulation of acts of physical and mental violence inflicted on the applicant while in custody and the especially cruel act of rape to which she had been subjected had amounted to torture in violation of Article 3 of the Convention. In addition, an allegation of rape by an official in custody required that independent doctors with the relevant expertise examine the victim with all appropriate sensitivity. That did not occur, rendering the investigation deficient and denying the applicant access to compensation in violation also of Article 13, which is right to effective remedy of the Convention. In this case, judicial protection of the victim has been assured directly by the court because of the failure of domestic legal order to do so. And there is another quite obvious way in which the court may intervene to protect girl children harmed by armed conflicts. And that is the case of girl children victims of armed conflicts who are asylum seekers in one of the contracting parties to the convention, whose claim is rejected at national level and who go to Strasbourg. As it is well known, irrespective of a situation of armed conflict in the country of destination, the risk of ill treatment in case of expulsion creates an obligation for the contracting party to the convention not to expulse the concerned person. I would like to stress that when it comes to the risk of ill treatment against women, the case law of the court is quite detailed and covers a number of specific occurrences like female genital mutilation, honor crime, and ill treatment by the family, risk of trafficking or retrafficking, and social exclusion. On social exclusion, an area that might be particularly sensitive when it comes to girl children affected by armed conflict, I would like to mention an interesting case, N versus Sweden, a judgment. I see Professor Pocard trying to say something, but
no, that's fine.
no, it's fine. Okay, it's a judgment of 20 July 2010. In this case, the applicant, an Afghan national having an extramarital affair with a man in Sweden. So this does not concern girl children, but it's interesting because it refers to social exclusion as a serious reason, serious ground to refuse expulsion, to impede expulsion from the point of view of the convention. So she had an extramarital affair with a man in Sweden and maintained she risked social exclusion, long imprisonment, or even death if returned to Afghanistan. Her application for asylum were unsuccessful. The court found that the applicant's deportation from Sweden to Afghanistan would constitute a violation of Article 3, prohibition of inhuman or degrading treatment or punishment of the convention. It noted that women were at particular risk of ill treatment in Afghanistan if perceived as not conforming to the gender roles ascribed to them by society, tradition, and even the legal system. The mere fact that the applicant had lived in Sweden might well be perceived as her having crossed the line of acceptable behavior. The fact that she wanted to divorce her husband and did not want to live with him any longer might result in serious life-threatening repercussions. The Shiite Personal Status Act of April 2009 required women to obey their husbands' sexual demands and not to leave home without permission. Reports and further shown that around 80% of Afghani women were affected by domestic violence, acts which the authorities saw as legitimate and therefore did not prosecute. Unaccompanied women or women without a male tutor face continuous severe limitations on having a personal or professional life and were doomed to social exclusion. It was clear that they also often lacked the means for survival if not protected by a male relative. In the special circumstances of the case, there were substantial grounds for believing that if deported to Afghanistan, the applicant would face various cumulative risks of reprisals from her husband, her family, her own family, and from the Afghan society, which fell under Article 3 of the Convention. In conclusion, I understand that we have not much time. There are clear limits to the protective action of the Strasbourg Court in this connection, especially because of its regional dimension, even though its moral authority goes beyond the limits of Europe, as we have seen in the Colombian case. Today, we are considering the future. Can one expect that the case law of the Strasbourg Court further develops in this connection? I am not concerned by the capacity of the European Court to cope adequately with situations occurring within the jurisdiction of the 47 contracting parties, which means Europe. Can the case law develop when it comes to the indirect protection ensured by the court in cases of expulsion or extradition? In this case, it is well known that it is not the ensemble of the rights enshrined in the convention and its protocols which is indirectly enforced, but only the so-called core rights, like the right to life and the prohibition of torture and other inhuman or degrading treatment or punishment. A defective judicial protection in the country of destination is not as such a reason to avoid expulsion or extradition. As we know, an exception to this principle has been affirmed by the court in the case of Othman Abu Qatada versus the United Kingdom, a judgment of this 17 January 2012. In that case, the risk incurred by Abu Qatada, whose extradition had been sought to the UK by Jordan, was not possible ill treatment, but the use in his trial in Jordan of evidence obtained by torture. So a risk linked to Article 6 of the Convention, i.e. judicial protection. In my view, it is not inconceivable that a further exception might be construed in the future by the case law of the Strasbourg Court in favor of girl children victims of armed conflicts and who are asylum seekers, when they do not risk ill treatment in the country of destination, but just a defective judicial protection. These situations might happen, for instance, in cases when, after serious troubles, an armed conflict is over and the concerned country is eventually stabilized, but an unsatisfactory system of transitional justice is put in place. So this is what I wanted to say from the point of view of Strasbourg. And I thank you for your attention. Thank you very much.
Thank you very much, Judge Raimondi, for your considerations. And I take your point, very important point, that although perhaps the court in Strasbourg will not have to deal directly with the protection of children from the point of view of the violations, the direct violation of their rights in Europe, but the case may be that their protection is ensured from the point of view of the access to a fair hearing and a fair trial. And the case you mentioned on the use of evidence that is inadmissible is a very important one. And we should not forget that although the court is regional, it has a high authority also in other international jurisdictions, which use the precedents of the court very frequently. Let me now give the floor. We move from the European Court to the International Criminal Court. And I will ask Professor Cadin to give his impressions of how the prosecutor of International Criminal Court has a strategy in order to protect the girl children. Is there something that has been done in the program of the prosecutor in order to protect girl children. Professor Cadrini, you have the floor.
Thank you very much, Professor Poccar, for the floor. Thank you to Professor Sergio Marchisio and to all the organizers. It's a great honor to participate in this initiative, also because for years, Sapienza University has been involved in collaboration with the Ministry of Foreign Affairs and International Cooperation in the study of Agenda 1325 of the Security Council. In particular, I directed the high-level training course, The Role of Women in Peace Processes and Mediation for Human Rights, founded 3 years ago by Professor Sergio Marchisio. Having only 7 minutes to talk about my topic, I will limit myself to articulating my speech into 7 synthetic points. Point number 1, I like to start remembering that the states at the Rome Conference committed to establishing the International Criminal Court for the sake of present and future generations. And in fact, millions of children, women and men have been and continue to be victims of cruel atrocities that deeply shock the conscience of humanity. Second point, as a demonstration of this, in the Roma Statute and in the document connected to it, there is no lack of rule that recognize the importance of crimes against or affecting children. These include enumeration both of crimes directed specifically against children, such as the war crimes of enlistment and the use of children under the age of 15 years to participate actively in hostilities, and also of crimes that disproportionately affect children, such as the war crimes of attacks on buildings dedicated to education and healthcare. Furthermore, this is point number 3, the ICC statute is the first international instrument to include various forms of sexual and gender-based crimes, qualified according to the cases as crimes against humanity or war crimes committed in international and non-international armed conflict. The list includes rape, sexual slavery, enforced prostitution, forced pregnancy, and other forms of sexual violence. The statute also, this is very important, criminalizes persecution based on gender as a crime against humanity. Sexual and gender-based crimes may also fall under the court jurisdiction if they constitute acts of genocide. The rule of procedure and evidence and the element of crimes of the court consolidate important procedural and evidentiary advancement to protect the interests of victims and enhance the effectiveness of the ICC work. However, this is point number 4, recognizing the challenges of the effective investigation and prosecution of sexual and gender-based crimes, in particular against children, the Office of Prosecutor elevated this issue to one of 6 strategic goals in its strategic plan 2012-2015, committing to pay particular attention to sexual and gender-based crimes and crimes against children. This commitment was very important and was reaffirmed in the following strategic plan, while in the last strategic plan, 2021, the third goal is of really interest for us, that is further develop mainstreaming of a gender perspective in all aspects of the court, judicial, and prosecutorial work. The policy paper on sexual and gender-based crimes and the policy on children, adopted respectively in 2014 and 2016 by the Office of Prosecutor, align with the strategic plan and will contribute to achieving the strategic goals. According to the policy paper on sexual and gender-based crime, the office has committed to integrating a gender perspective and analysis into all of its work, being innovative in the investigation and the prosecution of this crime, providing adequate training for staff, adopting a victim-responsive approach in its work, and paying special attention to staff interaction with victims and witnesses and their families and communities. According to the policy on children, this is the point number 6, crimes against or affecting children will be regarded as particularly grave, given the commitment made to children in the Roma Statute and the fact that children enjoy special recognition and protection under international law. Moreover, the office will make full use of the regulatory framework to address the various ways that such crime affect children. Wherever the evidence permits, it will seek to include charges for crimes directed specifically against children, as well as crimes that acutely affect children. So we finally arrive in 7 minutes to the last point. Thank you very much for your attention. And well, we look forward to seeing you at Sapienza University to attend our high-level training course on the Security Council Agenda 1325. Well, Professor Porcar, I'm done. Thanks again. Good evening, everyone. And you have the floor. Thank you.
Thank you, Professor Cadin, for your presentation on the agenda of the prosecutor in the International Criminal Court on crimes against women in general, but children in particular. It's very important that the ICC takes up this problem seriously on following on the case law that had been established by the 2 ad hoc tribunals for the former Yugoslavia and Rwanda, who started to prosecute these crimes when they were not really clear. The elements of this crime were not really clear in international law and were clarified on that occasion. Now, let me give the floor to Professor May Alshamari, who will comment on this question of the protection of children and girl children from Iraq. You have the floor, May.
Hello.
Hello.
Hello. Hello, everybody. I'm Dr. Maha Sakban from Iraq. Professor May Alshamari, she's assistant professor at the Middle Technical University of Baghdad. I'll give her the floor to speak.
Thank you, Maha.
Welcome.
We don't hear May. Is there a problem of connection?
Yeah, problem with the connection. She is joining us.
Hello, I'm May from Iraq, and I'm very happy with your team.
We hear you, please.
Yes, you know this problem not in Iraq country, as many countries in the world who have wars.
Yes.
Yes, the family situation when the father or mother death, they not have a place to live in it. They will go in the street, and the children under the age of 15 years, they will lose every human rights for them. The United Nations defines children around conflicts as any children associated by a military force or a military group under the age of 18 years age, and who is still or was correct of used by the military force. Will include one example will be not limited to children, boys or girls who beginning use their worries, cooks, proteins, soaps, or for sexual purposes. In the more than half or warring countries around the world, report indicated the percentage of children complaints. Among the reason that lead to the participation of children in the military operation as a campaign are the research for safety, protection, and food, feeling or freedom, humanity, and protection. And in our Arab religion, especially in Syria, Iraq, and Yemen, children are becoming necessarily to military recruitment as well, are becoming the target for attacks and physical violence and the disability of armed group. And the small armies and light weapons and the easy available have lead to the recruitment and use the humanity of children from the virgin parts of the Arab religion. The problem of child recruitment of the mass communication problems focus on the rights of children and the matter of concern to the international community. Slow movement from until to prevent their curriculum of second option total additional of Geneva Convention August at the 1977 and the other not least Coben. But it detail with the subject in the prefect test, after which I was not logging before the parties of the treaty religion that the treaty alone was not sufficient to prevent child requirement. Iraq, followed by international lead in the addressing child requirement before the Iraq follow the international lead in the addressing child requirement by reflecting of the Convention on the Rights of the Child of the 1989, and also reflected of option political of Geneva on the involvement of children in armed conflicts of the 2000. But the problem, as the internationally has remained a local harm that has not been eliminated or even an available cases and effect of child requirement. And requirement. The reason is around in Syria and some African countries are these the same in Iraq, which different effects in each country. The same effect and conspection are left by the forced requirement of children, even to vary degree from the country another. Poverty plays an environment role in the requirement of children, especially in cases where they are required by the armed force into regular groups, which many promote their families to encourage them to join this, or that groups agree for a material ability, simple and free, and perhaps in many cases to generate a meal one of the food. There were many armed groups in Iraq, such as SS, paying between $100 and $135 per every month. Discrimination has also played a role, no less than poverty, in pushing to require children and boys to join armed conflicts, considering to defend that the defense of a defense is an effect factor in the mobilizing local communities and their children, in addition to social factors that prepare more clear in the Africa and an area of international conflict in the Middle East. Normally, this is the supremacy of triple value over the value of law and the state, which made clean and easy was to resort to them to option to right. With weak government proposition, and there are many negatives association with the triple value, such as advantage along their other factors such as immigration and poverty. And then the policy situation has played a prominent role in the requirement of children by making them means that they are armed groups and their removement explode. This is involved the fact of representing the repressing of child requirement crime and the poor policy situation is a major case in many international confidence. At the many of these confidence lead on the increase of increase in number of child. We do not exercise the truth if we say that for the sake of has been a placing of this region. The political station in Iraq under rule it has played since 2003 until today in providing international conflicts, premised in the war or terror. We need to provide and provided a wrong, nurturing environment for the stray children in order to protect them and bring them into the society through the first physical and health care and provided them. We financial support through the positive of sanitary job operations. Yes. Yes, and you see this the sexual. You can see the number of child required country, number of who is in the countries. Somalia is take the number 2022 to 1 for child requirement. Nigeria 1092. Congo 1049. South Sudan 1021. Syria 961. Yemen 842. Afghanistan 643. Iraq, the number is 523. Myanmar 491. Central African Republic 291. We can take in Iraq. The statement of Ministry of Immigration and Displacement include the number of refugees and those remaining in disability, about 3,836,289. Disability person will return 343 and 550 return in Iraq from the camps. We have in Iraq 1,107 camps to the house. 383 and 70, 20 families living in the campaigns, preparing of person, 56% of the total number of families.
Okay.
Okay, I will show that is the study case for my paper.
Okay.
Thank you to listen to me. Thank you.
All these documents, you can provide all this documentation, which is very interesting, in a document you send us in order that we can distribute it also to the other participants with these statistics, which are important. But I thank you very much for having given these comments on.
Thank you.
On this.
And thank you. I'm very happy to sharing with you on this conference. Thank you.
And I hope we remain in touch in the network. Let me now give the floor to, coming back to Europe, to Professor Dragos Cilea and Madalina Botina. They have two speakers who will speak of the protection of girl children in Romania, and we will take the floor using splitting the time you have as you wish, Dragos and Madalina. You have the floor.
Oui, je vous remercie beaucoup, Président, Monsieur Professeur Poccar. C'est un grand honneur pour moi et pour ma collègue Professeur Botina d'être invité ici parmi des professeurs d'une grande valeur et parmi des juges et des professionnels. On va partager notre timing pour présenter deux choses. Aujourd'hui, dans cette journée exceptionnelle dédiée aux droits des enfants, je vais vous parler quelques mots du point de vue du barreau pénal international que je préside depuis une année. Donc, on a fait une stratégie avec professeur Laura Guercio, que je lui remercie vivement de m'inviter ici, pour associer le barreau pénal international à toutes les démarches et les activités pour mieux protéger les enfants et notamment les filles victimes de guerre. D'ailleurs, l'année précédente, il y a une année jour pour jour à peu près, le 13 novembre l'année dernière, à Bamako, nous avons eu notre premier congrès en Afrique, le congrès de barreau pénal international, et nous étions honorés par la présence de Madame Fatou Bensouda. Et à ce moment-là, on a signé une déclaration et on a discuté d'un congrès sur la protection des femmes victimes, et c'était prévu pour Banjul. Mais à cause de cette pandémie, on a eu pour l'instant ajourné le congrès, mais on va le refaire ensemble. Ce que je voulais vous dire aujourd'hui, c'est que les avocats, et notamment ceux de barreau pénal international, à mon avis, doivent être plus présentes à côté des victimes. Les victimes de guerre, femmes et filles, sont des êtres très fragiles, des êtres démunis. Et donc, ils ont besoin d'une plus de défense de la part des avocats. Aussi, je voulais faire vous observer que ces victimes sont des victimes avec une spécificité absolue, parce que les enfants, les filles victimes de guerre sont démunis d'une certaine possibilité de communiquer avec les avocats, avec les autres acteurs d'une procédure pénale. Donc, c'est le rôle de l'avocat d'être plus présente et de défendre d'une manière spécifique ce genre de victimes. Après, donc, il y a le problème de monter les plaintes de victimes vers les instances nationales ou internationales. Ici aussi, on a discuté du rôle de l'avocat et on a pensé d'ouvrir un bureau de barreau pénal international à Bamako pour être plus proche avec notre confrère et consoeur des victimes qui sont en Afrique, parmi les femmes et parmi les filles victimes de guerre. Pas pour le dernier chose, on pense aussi sur la stratégie que les avocats doivent avoir pour les réparations que les victimes, filles et victimes de guerre, doivent avoir, parce que ce n'est pas pour faire seulement la justice, pour punir les coupables, mais aussi pour faire la justice, pour essayer de rendre une réparation matérielle et morale à toutes les victimes qui ont subi des graves violations de la part de ceux qui sont coupables. Donc, dans cette démarche, je pense, pour faire une démarche de préparer dans une formation continue les avocats. D'habitude, et pourquoi pas le reconnaître, les avocats sont spécialisés pour défendre les coupables. Donc, je pensais que c'est aussi important qu'il y a des avocats qui doivent se spécialiser pour défendre les victimes et pour voir d'un autre côté la défense. Et dans cette démarche, bien sûr, que les victimes enfants et les victimes, notamment les filles et les femmes, doivent bénéficier d'une défense très pointue et très spécialisée. Maintenant, je m'arrête ici avec mes remerciements encore une fois à professeur Marquisieux, à professeur Fausto Pocar, que j'ai un grand honneur et un plaisir de le revoir, et à Laura Guercio. Et avec votre permission, j'invite ma collègue qui est avocate de peuple à Constanța et elle va vous présenter dans quelques mots la situation des enfants victimes qui arrivent sur le territoire de Roumanie. Je vous remercie, Monsieur Pocar.
Merci, Dragos. Maintenant, Madalina Botina.
Bună giornata.
You have the floor.
Thank you very much for the invitation. I will try to share my screen if that is possible. If not, it's not a problem. I wanted to say some words about the duties and the actions of the People's Advocate regarding the protection and promotion of the rights of the child. The People's Advocate in Romania, it's an ombudsman institution with general jurisdiction, which has as purpose the defense of individuals' rights and freedoms in their relationship with the public authorities. But also, it is very important for this institution how the children's rights are respected here in our country. In this regard, the representative of the United Nations High Commissioner for Refugees in Romania referred to the People's Advocate institution, pointing out that in a recent month, the institution that he represents received several notifications that several children have remained in the Regional Center for Accommodation and Procedures for Asylum Seeker in Bucharest, which is administered by the General Inspectorate for Immigration of Romania. These children would be accommodated with adults. The legal representatives are appointed late for them, and the situation regarding the accommodation is determined by the lack of places at the Pilot Protection Center for child victims of trafficking in human beings in Bucharest, the only unit which is designated for the accommodation of unaccompanied minors which are seeking asylum. Seeing this situation, in this regard, the People's Advocate ordered an investigation and which determined the situation of the minors. At the time of the investigation, which was in the first part of this year, the center housed both accompanied and unaccompanied minors with different status as follows. A number of 29 minors seeking asylum were in that center. 9 minors were refugee status and 2 minors who were granted subsidiarity protection. As for the unaccompanied minors, there are 15 of them as follows: 14 asylum seekers and 1 with subsidiary protection. Of these, 4 are under the age of 1 year. Regarding the situation of the minors, for all the 15 unaccompanied minors, the General Directorate of Social Assistance and Child Protection requested to appoint for them a legal representative, and also they had to take over in a residential center for those under the age of 1 year, for the children with a small age like that. And the survey observed that only 9 minors had a legal representative at that time, while 6 of them had not yet responded to the requests made. So after the investigation, of course, the people who went there to see also the conditions in which the children were housed confirmed that they were living with the adults in the same rooms. They didn't have special rooms for them, which was in fact not a pleasant situation for them. Also, the investigation that the Romanian ombudsman made regarding the documents, the asylum application, were completed. The information forms regarding the rights and obligation were also completed. They were informed for the Dublin procedure. They had some preliminary interviews and the background interview, and the decision to grant and reject refugee status or subsidiary protection. So all this part of the documentation was all right, but the conclusions of this investigation were that the Regional Center for Accommodation and Procedures for Asylum Seekers in Bucharest has applied for the appointment of a legal representative for all unaccompanied minors, as well as for taking over in a residential service for unaccompanied minors up to 1 year of age, but also for one of the minors over the age expressed agreement in this regard. So the recommendation of the People's Advocate was that the director of the Regional Center of Accommodation and the Procedure for Asylums in Bucharest is to, in the exercise of his attributions provided by the legislation in force, to order the legal measure for accommodation of unaccompanied minors separately from adults, of course, because there were some problems regarding this aspect, and starting the specific renovation works of the center in order to improve the accommodation conditions. So even if the legal framework is good in our country, we have also to make some investigations and to see the reality as it is. So this is what our institution does. Thank you very much.
Thank you very much, Madalena, for this presentation of your office. And of course, you put the accent on minors that are coming to the country. Yes. And coming from areas of conflict. So the protection is another topic that has to be taken into account in our work here. So thank you, and thank Dragos for his presentation of the role of the defense in the protection of rights, which is an important issue. In this respect, I'm sorry we don't have one of the speakers, because he's in the hospital, we had one of the speakers, there was Professor Mwalgawa, that was coming from the Democratic Republic of Congo, and he was going to speak of the role of the defense, of the lawyer, defense. It's a difficulties. That's a country that has difficulties for conflicts that took place there. But we will have probably his presentation on another occasion. Now, let me give the floor to Professor Silvia Scarpa, that comes from Rome, who will speak of the judicial protection against forced marriages. Apparently is a topic that is outside of the conflicts, but we have to bear in mind that forced marriage is a way of enslaving children. So it's a way of having a sort of enslavement of girls in particular. And this may be also a means of recruitment, because these enslaved children then work also, are used also in war, in armed conflicts. So Professor Scarpa, you have the floor now.
Thank you very much, Professor Pocar. Honorable chair of this panel of experts, Professor Pocar, distinguished colleagues, ladies and gentlemen, let me first of all thank you very much to the organizing committee for this network of universities and for the opportunity, obviously, to deliver this speech today. I think it is very important to celebrate this year the 20th anniversary of the optional protocol to the Convention on the Rights of the Child on the involvement of children in armed conflicts, because of the fact that actually this is an issue, as also Professor Pocar was mentioning, that presents certain peculiar aspects that need to be examined, also in light of my speech in respect of child early and forced marriages. I'd like to share, first of all, with the honorable panelists and the ladies and gentlemen of the audience, information on the activities I conducted at John Cabot University of Rome during this week. Given that in 2019, I introduced in the academic curriculum of the university a course on human trafficking and contemporary slavery, and that classes are held twice per week. Last Tuesday, on November the 17th, I discussed with my students about the issue of child soldiers in armed conflicts. And then on the 19th, so yesterday, we discussed about peace support operations and the issue of human trafficking, as well as sexual abuses and sexual exploitation. Mm-hmm. I also obviously extended an invitation to the students of all my courses to attend this webinar. Let me now get to the paper that I would like to present today. As I said, I would like to focus on the issue of child early and forced marriages during armed conflicts, so with a focus on armed conflicts. I decided to focus on this issue because I think it is important, but honestly, it is also an overlooked issue during armed conflicts, and one that, according to me, notwithstanding the lack of specific provisions included in the statutes of international criminal tribunal and courts, has seen recent interesting jurisprudential developments. I believe that this network of scholars offers to us the chance to work in a direction that consolidates such important developments, as well as on one direction that allows us to assess and eventually reconsider the fragmented nature of international law in this area, in the area of child early and forced marriages more broadly, and then also in particular for what concerns armed conflicts. Consider that, in my view, the issue of child early and forced marriages is somehow subdivided, at least in 4 or 5 branches of international law, namely international human rights law, international slavery law, or slavery and international labor law, if you also keep into consideration the issue of the worst forms of child labor, international humanitarian law, and international criminal law. Why, first of all, is this an issue? I think that actually it is important to discuss in this panel on the strengthening of the judicial protection of children affected by armed conflicts, this issue of child early and forced marriages, because I think, and that's what will be my proposal at the end of this paper, that actually, since a procedure is available for proposing an amendment to the optional protocol on the use of children in armed conflicts through Article 12 of the optional protocol, then it would be possible to use this chance to provide an advancement and some kind of a solution, or a partial solution at least, to this problem of the fragmentation and still limited actually relevance of some of the rules that we have within international law in the area of child early enforced marriages. Why is this an issue in terms of estimates? The estimates that we have tell to us that the issue of child early enforced marriages is a huge issue. During peacetime, definitely consider that UNICEF estimates that every year 12 million girls under the age of 18 are married off, and that a total estimate of women who are married underage is 650 million, so in the world. Consider as well that the issue is relevant in armed conflicts because we have recently seen many cases of girls, young girls and women being abducted. Consider the cases, for instance, of the Islamic case, the Islamic State, in Iraq and Syria, the case of Boko Haram in Nigeria, Al-Shabaab in Somalia, as well as the Taliban in Pakistan. Consider, just to make a few examples, the case of Boko Haram, where actually in 2014, the leader of the group, Boko Haram, Sheikh Ayyub, said publicly that we would give the hands in the hands of these women in marriage because they are our slaves. So going back to what Professor Pokar was emphasizing, considering actually women as slaves in a way and given up in marriage for this reason. He continues by saying we would marry them off at the age of 9. And we would marry them off at the age of 12. So also emphasizing the very low ages at which actually women should be considered of a marriageable age. Similarly, ISIS established the so-called marriage bureaus. So actually markets where women could be sold. And we have actually the story in particular of Nadia Murad, a Yazidi woman who won the Nobel Peace Prize in 2018, as well as the stories of many other Yazidi women testifying actually how they were sold and given in marriage to the men fighting for ISIS. If you look at that, the optional protocol on the use of children in armed conflicts remain silent on all these issues. As it was emphasized already on Monday during this conference and also by many other scholars, notwithstanding the fact that in her groundbreaking report of 1996, Graça Machel had emphasized the effects of armed conflicts on girls as well as on boys. This issue actually was overlooked when the optional protocol was adopted, and the coalition to stop the use of child soldiers that promoted the adoption of the optional protocol somehow portrayed an image of boys mostly as, you know, carrying firearms as the ones who are involved in armed conflicts. So this image, I think that obviously given the evidence that I was providing needs to be changed. And also obviously the rules within the area of international law need to be ameliorated for this reason. As you know, we have, going back obviously to the rules of international law, a variety of problems. First problem connected actually with the issue of the age of majority. The UN Convention on the Rights of the Child defines a child as every human being below the age of 18, but then it adds, unless the law applicable to the child states that majority is attained earlier. We also know that in many countries of the world, the age of majority, meaning obviously the age at which a child attains adult rights, can differ from the age, the lawful age for marriage, as well as the lawful admission at work, thus obviously providing for the distinction between child work and child labor, the age for criminal responsibility, as well as the age for enlistment in the armed forces, also for what concerns states, which is an issue that the protocol, the optional protocol, deals with. If you look at the issue in terms of child marriages or early marriages, what we have in terms of international human rights law is very much limited, and I'm sure that all the speakers and the panelists here are very much aware of that. Article 16, paragraph 2 of the UN Convention on the Elimination of All Forms of Discrimination Against Women, as well as Article 2 of the 1962 United Nations Convention on Consent to Marriage, minimum age for marriages and registration of marriages, only say that states have to provide a minimum age for marriages, but they're not saying which age actually they should include into their national legislation. We know that there has been an attempt by UN monitoring committees, monitoring bodies, as including the Committee on the Rights of the Child, as well as the Committee on the Elimination of Discrimination Against Women, most recently in 2014 with this joint recommendation, general comment provided by both of them, in which they try to push states to provide as a minimum age for marriages the age of 18, so the age of majority. But as I said, again, we have huge issues. Consider that I had found evidence from a report from the ILO and the Work Free Foundation that actually claims from 2018, that claims that probably as many as 133 countries in the world have not yet criminalized forced marriages, with not so much information on child and early marriages. Consider that I have recruited this semester 5 students for working on a database to clarify this issue. So if we can get up, with more information on all the states of the world to clarify the picture on this. So the picture is a bit unclear at the national level. For what concerns other standards, consider that under international slavery law. So as I said, in the area of international human rights law, as I said, the picture is fragmented with actually not so much information provided, besides the fact that actually marriages have to be concluded with the consent of both spouses, with the fact that actually there have to be witnesses at the ceremony. But these are minimum, let's say, requirements. For what concerns international slavery law, in 1956, we have seen the adoption of the United Nations Supplementary Convention on the Abolition of Slavery, the slave trade, and institutions and practices similar to slavery. And this convention somehow considered as institutions and practices similar to slavery, certain practices affecting women and children. So situations in which actually, as you can imagine, women can, without a right to refuse, be promised in marriage to a third person, or if actually the husband or a woman has the right to transfer her to another person for value received or otherwise, or if actually at the death of the husband, they can be inherited by somebody else. And then there is also a very general definition of the exploitation of children, which might also include situations such as early and child marriages. For what concerns, and this is actually the conclusion in terms of human rights law, for what concerns international humanitarian law, actually the issue of child early and forced marriages is not mentioned. As you know, there are many provisions in common Article 3, first of all, of the 1949 Geneva Conventions that discuss, first of all, about outrages upon personal dignity. Then we have specific provision in the Geneva Convention number 4, Article 27, that talks specifically about women and their protection. But this provision has been kind of criticized because, and I quote, it says, women shall be especially protected against any attack on their honor, in particular against rape and forced prostitution or any form of indecent assault. And this issue of honor somehow raised, especially concerned in feminist, let's say, scholars in the area of international law, because it seems that it provides a point of view that's mostly from men, imposing this idea of honor in a way on women. There are then specific provisions included in both additional protocols that focus very much on the issue of forced or enforced prostitution, rape, but somehow there is no specific reference to the issue of child early and forced marriages. In the ICRC, the International Committee of the Red Cross manual for customary rules of international humanitarian law, what we find is only Rule 93 that says that rape and other forms of sexual violence are prohibited. And this takes us actually also to the analysis of international criminal law. So this issue of sexual violence as being the predominant framework under which this issue also of child and enforced marriages is considered. So as a conclusion on humanitarian law, I'm sure we see that this issue is kind of lacking and it should be coming out of interpretation. For what concerns international criminal law, the issue has been dealt with in terms of case law. Okay, so in the statutes and treaties that led to the adoption of international or internationalized courts and tribunals, we do not have any specific provision on child and enforced marriages. what we see is that through interpretations, but then the interpretations in the case law go in two directions. One is actually to subsume this issue of childhood and forced marriages, in particular the issue of forced marriages, and so child and early marriages are kind of left behind. But the issue of forced marriages gets out as a form of a crime of sexual slavery, or as a crime against humanity, obviously, or in the other possibility, it is actually coming out independently, but under the label of other inhuman act. So we have seen, and I would like to mention the specific cases quickly because I know that I'm running out of time,
Yes.
Professor Poker. And so for what concerns this interpretation in respects of a crime against humanity of other inhuman acts, so we have seen, first of all, the first case was actually the appeals chamber of the Special Court for Sierra Leone that actually mentioned this issue in the Prosecutor versus Brima, Camara, and Kanu case. And then we have seen in 2008, then we have seen the extraordinary chambers in the Court of Cambodia in the case 002/02 from 2018, so again, considered as other inhuman acts. And then recently we are seeing the ICC, the International Criminal Court, the pretrial chamber 1, in the case of Prosecutor versus Al-Hassan. And again, also here, it seems that the focus is on forced marriages as part of these other inhuman acts. So to get quickly to my conclusion, I am skipping a part of the discussion. It's obvious that discussing about forced marriages in terms of international criminal jurisprudence, the focus gets diverted on the conjugal element of the exploitation in a way, instead of the element of slavery or sexual slavery or enslavement. And this is actually the discussion that we have internationally. As I said, I think that I have well demonstrated again with this reference to the various branches of international law that there is a fragmentation of international law that would require to be tackled. And I think that actually through the procedure provided by Article 12 of the optional protocol on the use of children in armed conflicts, which provides that actually any state party to the protocol may propose an amendment to the Secretary General of the UN. And I think this is a very interesting possibility which is offered also because actually then this might lead obviously to a conference of the states, and then the amendment which might be proposed according to paragraph 2 which is adopted in accordance with paragraph 1 can enter into force if it is approved by the General Assembly of the UN with a 2/3 majority of the states parties. And here I conclude my discussion. So I obviously would go into this direction for providing amendments. So I thank you very much for your attention, and obviously I remain at your disposal for eventual questions. Thank you very much, Professor Poker.
Thank you very much, Silvia, for this presentation of the topic, which is, in fact, as I suspected, very much related also to situation of armed conflicts. We conclude, of course, we didn't have enough time to discuss all the topics. We are getting out of time, out of schedule. But I wish to thank all the speakers for their presentation, for their contribution to this discussion. This shows that this is the first conference this network is doing, but this shows that we will have a lot to do in the future, and to go more deeper into all the subjects that we have on Monday and today considered in a way so quickly. Just to give a first impression of the topics, we will have to streamline our efforts to go more in depth. You mentioned, Silvia, also the possibility of an amendment to the protocol, and that too could be a work for the network in this case or other cases as well.
Hello.
Recommend changes to the law when this is necessary. So with this, I conclude this panel, and we'll give the floor. We are exactly on time, on schedule. We'll give the floor to my friend and colleague, Professor Marchisio, to deal with the implementation of the UN Security Council Resolution 1325 on women, peace, security in order to protect girl children in armed conflict. Sergio, you have the floor.
Thank you very much, Fausto. So we kept the break, of course, because of being out of time.
Use the break for working.
Okay, thank you. And while the first roundtable was about the judicial protection of girl children, we are now dealing, as Professor Poccar already mentioned, with the United Nations Security Council Resolution 1325 on women, peace and security. How this process addresses girl children in armed conflict. We have some references in the texts that are relevant for the process of women, peace and security, starting from Resolution 1820 of 2008, which clearly refers to girls as particularly affected by consequences of armed conflict and systematic forms of violence based on rape and other forms of sexual violence. Then we have another reference in the 2019 Secretary General reports, who underlines another form of harmful practices affecting girls, namely the child marriages that were just talked about by Professor Scarpa. And then, of course, there is also the the general recommendation number 30 of the Committee on the Elimination of Discrimination Against Women Monitoring Commission, which said that discrimination against women is also compounded by intersecting forms of discrimination. As the convention reflects a life cycle approach, state parties are also required to address the right and distinct needs of conflict-affected girls who arise from gender-based discrimination. Then I listed the need for more effective intervention by criminal justice for the detection and repression of crimes of violence, and finally, the disproportionate negative impact on the pandemic on women and girls, as recent United Nations Security Council Resolution 2532 has underlined, called for concrete actions to ensure the full, equal, and meaningful participation of women and youth in the development and implementation of an adequate and sustainable response to the pandemic. So to speak about these issues, we have a panel of distinguished speakers. As I understood from Professor Poccar, Professor Jules Thomas Mukadi will not be with us today. He was foreseen in this panel, but the others, I hope they are present today. And I will start with giving the floor to Professor Jan Fritz, who is from the University of Cincinnati, USA, United States, which will deal with items that need to be included in effective national actions plans based on UN Security Council Resolution 1325. Professor Jan Fritz, you have the floor, please.
Yes, can you hear me?
Thank you very much. We can hear you. Please, the
Yes.
floor is yours.
Yeah. Thank you very much for the invitation to take part. I write about the Security Council resolution, the national action plans that resulted from it, and localization efforts. Let me start by saying there's so many important issues that vie for our attention. particularly after the election in the United States is one of them. We can hopefully put that to rest, except the president hasn't yet. One of those important issues is armed conflict and how it affects children. The most recent report, June 2020, from the UN Secretary General, talked about 25,000 incidents or violations of children in 19 regions. The question is, do people know about this and how can it be addressed? Let me do this in 4 points in a very short time. First of all, why do we have national action plans? The Security Council resolution in 2000 did not mandate national action plans. It took 2 to 4 years for the head of the Security Council and the head of the UN to recognize that if you wanted to be effective, you need to get closer to the situation. So it was a good thing to have something international, but there also needed to be something national. But the national action plans were never mandated. You didn't have to do them. So let me come to our 4 points here. One, the first is, why do we have these national action plans? And I've just said that. The second is, how many national action plans are there? These national action plans are for women and girls, both about protection as well as their active involvement in society. The most recent report from the UN Secretary General in 2020 indicated that there were 85 national action plans out of 193 countries. And frankly, I think 85 is a high number for that, because national action plans have years in which they cover. And so frequently a country may put a plan in place, but there may be years before it has a next plan, or its plan may have expired. And even when you look at 85, there are 193 countries. So we're not even talking half the countries, even with the highest number of count of plans having put in place. And of those plans, that same UN Security Council resolution connected to these plans, it indicates something like less than 25% have a financial contribution in connection to the plan at the time the plan is put in place. So thinking about that while we continue to talk about this, and what should be in a national action plan. Well, there are 2 things to mention here. One is there's a difference in the national action plans from donor countries and countries that are in conflict. Countries in conflict frequently focus on what's going on in their country, and that would be more likely to mention the effects on children in conflict. The other national action plans frequently don't talk about what's going on in their own country. They only talk about what's going on in countries they give money to. And you think that's kind of strange. If you're thinking you want to be helpful, why don't you talk about your own country first? To what extent are women and girls included in that country? So we have a very limited number that you can actually expect for somebody to be talking about children in armed conflict. What's in a national action plan? It should have the number of years that are covered. But also, it's a government plan, but it's supposed to work with civil society. And that means both not to attend a meeting where somebody tells you what's going to be in it, but that you're involved in all stages of the action plan, the development of it, the implementation of it, and the monitoring of it as it goes along. Again, because of time constraints, I'm not going to go through all the kinds of pieces that you would find in a national action plan. But the question is, and if you start to read the information that's available, there are so many things that could be in a national action plan that perhaps children in armed conflict is not going to get the kind of attention that it might need in general. And that's why both in the report from the UN Secretary General on children in armed conflict, if you get to the end of this very difficult item to read, it talks about the importance of having national action plans based just on that topic. So I would urge you to think about 2 ways to do this, not only to include it under a 1325 plan, but to have a separate document which talks about children in armed conflict, whether it's in your country or you're a donor country giving to countries that have this situation. And the last point I'd like to make is about levels of intervention. I've been talking here about the importance of an international mandate. The 1325 is not a mandate to some, but it's a suggestion. Certainly the national action plans weren't mandated. Those were just suggested, but those are two levels of intervention. We've learned from COVID-19 that it's really important to have individual commitment to doing something about it. So I'd like to underscore at a national level the importance of political will, but also in looking at all these levels of intervention from individual to local community to national and international. People have to come along with whatever you're doing. That means they have to be educated about the topic and they have to feel a commitment to doing something about something. As we've seen with COVID-19, countries that people have been willing to wear a mask or have worn a mask before, or understand when a country is told that this is needed, where people obey it, we've seen differences. It's the same here. We need to have individuals coming along to think these are good ideas. So it's good for a local community, it's good for a national community and international, but we also need individuals to be brought in. The earlier you can get people involved in discussing this, the more likely you have something to happen. Anyway, thank you very much for letting me talk for a brief time, and I look forward to the other presentations.
Thank you very much, Professor Fritz, for having underlined the importance of localization efforts in order to have effective national action plans, and for giving some recommendation of how to craft the national action plans according to the category of countries you belong to. Now we have another speaker, who is Professor Quito Masimango from de l'Université panafricaine de conformité océanique from the Democratic Republic of Congo. Are you there, Professor Masimango?
Sorry, it seems he has some problem with the connection. He's trying to connect, so we can.
What should I do? Give the floor to the next speaker in the meantime?
Yes, I would do so.
Thank you. So, as we see in the program, next speaker is Professor Settimio Stallone from the University of Naples, Federico II, Italy, and he will deal with the topic of in the country of the forgotten God's army, Myanmar, and the United Nations Security Council Resolution 1325. Professor, you have the floor, please.
Thank you very much, Professor Marchisio. I'm very glad to be here, and I would like to thank the organizer for having invited me in this important and very interesting conference about the Security Council Resolution 1325. I know that we don't have many time, so I think that the better option is to immediately start with my speech that is about the resolution regarding a country in Eastern Asia, Myanmar. I have chosen Myanmar as a case to explain the situation of the resolution 1325 in Asia, because Myanmar, since its independence after the end of the Second World War, has suffered a number of civil wars with large involvement by children, and especially female children. And also because in Myanmar we have a particular story in the period between the end of the 19th and the beginning of the new millennium, when in Myanmar, in one of the civil wars that involved Myanmar in this period, we had the God's Army. The God's Army was a Christian insurgent group recognized by a relevant part of the international community as a terrorist organization, active in this country and also in Thailand. It fought to defend the rights of the Karen ethnic group, politically united in the Karen National Union. Why the God's Army could be recognized as important for the resolution 1325? Because in this group, in the period between the end of the 19th and the beginning of the new century, this group was led by two brothers, Johnny and Luther II, that in those years were only 10 years old. A legend particularly widespread among their followers said that they had not human but divine powers, able to defend the Karen people and the villages from the Burmese authorities that fought them. Adopting an austere lifestyle based on abstinence from sex, alcohol, and some animal foods, and conscripting children, they gained some victories in facing the Burmese army between 1997 and 2001, seizing the Myanmar embassy in Bangkok in September 1999. Kto Twins Group was progressively dismantled between 2001 and 2006 due to some defeats against Thai and Burmese armies. I haven't thought that this story has a happy ending, because the brothers now live in Sweden and they are perfectly integrated in the Swedish society. I think that it can represent a good starting point to examine the situation of the implementation of this resolution in Myanmar. At the moment, unfortunately, the Burmese authorities haven't adopted a national action plan to implement this resolution. That is obviously fundamental, not only to avoid the involvement of female children in fighting and also in terrorist activities, but also to promote a better integration of women in the Burmese society and in the difficult, still ongoing peace process between the government that is led by the Nobel Peace Prize and also de facto Prime Minister Aung San Suu Kyi, and a very large number of ethnic and political organizations that exist in this country. As you certainly know, unfortunately, the reception of the resolution 1325 has at the moment been quite slow from Asian countries. Regardless the irrelevant case of the small and peripheric Nepal and the Middle East region, that obviously is part of Asia, but it's a region that we can consider as a different geopolitical area. Indonesia was, only in 2014, the first Asian state to introduce the implementation plan, after almost 10 years after the endorsement of the resolution. As of October 2020, only the small Timor East and Bangladesh have followed this example. In this critical context, we so can introduce the difficult condition of Myanmar. At the moment, the authorities are handling negotiations or fighting with more or less a dozen of armed groups. This situation has provoked relevant consequences, not only in a political manner, but also for Burmese society, whose women have been largely affected, particularly in ethnic areas. Today, nonetheless, this country has, as I told before, a female prime minister. It's difficult to imagine a real involvement of women in negotiating and managing political and social peaceful processes. Instead, in Myanmar, sexual and generic violence, human trafficking, lack of basic services and commodities, socioeconomic disparities are strongly suffered by women, exposed to a situation characterized by burdens and vulnerabilities. Due to this consideration and this situation of permanent ongoing civil war, we can presume that an implementation of the United Nations Security Council Resolution 1325 and the adoption of a national action plan should be based on the second, the third, and the fourth pillar of this resolution: protect and prevent women from violence, relief and recovery women directly or indirectly affected by consequences of the civil war. In 2013, the Myanmar government approved a 10-year national strategic plan for the advancement for women, which identified 12 priority areas of intervention, included some finalized to strengthen women's role in decision-making and institutional mechanisms. But still much is necessary to done to accomplish the United Nations recommendation. Women's presence in governmental bodies is quite limited at the moment, and their role in negotiations with armed groups is now very marginal. Also, regarding the aim of protecting the women and preventing violence against them, nonetheless, the Burmese armed forces have recently adopted some strict rules to tackle this issue. The lack of independence of judges and the general impunity constitutionally recognized in favor of the military personnel, combined with, it's typical in these Asian countries, a male-oriented social tendency, have produced the poorer results. Some local and international non-governmental organizations have recently organized some initiatives directed to increase awareness of the Burmese society towards these issues. We have at the moment in Myanmar 2 organizations connected with Burmese non-governmental organizations. The Women's Organizations Network Myanmar, that includes more than 30 groups involved in this campaign, and the Women's League of Burma, that consists of organizations that oppose the current government. At the end of 2018, the United Nations High Commissioner for Refugees estimate that more than 1 million Burmese refugees are in camps inside the Thai and Malaysian territories, in certain cases with settlements originated during the 80s. In December 2019, the United Nations calculated that further 217,000 people, 70% of which are female and children, live inside camps in Myanmar. It's understandable that due to this tragic situation, a national action plan that should implement the 4th pillar of the United Nations Security Council Resolution 1325 is strongly necessary, but not only to ease the intervention of the international organizations, but also to develop an efficient action by Burmese NGOs that obviously need a strong assistance from the more skilled international NGOs with a positive perspective for the future. In conclusion, the international community and the United Nations should act to persuade, bolstering their capabilities, the Burmese authorities to adopt a map able to include all the recommendations part of this resolution, possibly based on the 2013 plan that, nonetheless, it has some weaknesses, particularly in the promotion of the role of women in conflicts mediation and their defense against violence, could represent a starting point, and this a decent starting point. This plan must be accompanied by some judicial reforms, particularly in the field of the unacceptable protection given to the members of the armed forces. Last, unfortunately, almost now, the government of Myanmar and a large part of Burmese society seem not to understand the importance of this resolution and are mostly committed to think that violence will cease with the end of the civil war and aren't able, au contraire, to imagine that a serious policy towards violence against women and children could represent a good first step to reduce, potentially stop the fighting in this country. I have concluded my speech, and I thank Professor Marchisio and the other participants to this conference for having listened to me. Thank you very much.
Thank you for Professor Stallone for your real interesting presentation concerning the Myanmar situation in the perspective of the national implementation plan of the Security Council Resolution 1325. Is a case study, very, very interesting. Now we move to the next speaker, and I realized that Quito Masimango couldn't connect to this webinar. So for the time being, I continue with the next speaker, which is Dr. Janet Servat Boateng from the University of Cape Coast, Ghana, who will deal with the women's unique role in protecting girls in conflict. Experiences from Ghana. You have the floor, Dr. Janet.
Good evening. Can you hear me, please?
I could hear you, but I don't know what happens.
And discuss gender-specific effects and women's ableness to resolve conflicts, negotiate for peace, and provide humanitarian responsibilities, which in turn protect girls in conflict areas. I would like to share with you a short description of how local women are taking advantage of the relatively peaceful atmosphere in Ghana. Every day, I go for a walk within a town noted for its business activities in the central region of Ghana. At the early hours of about 5:45, most of the people I meet are local women, busily arranging and displaying their wares for trading activities to take off when they break. You know, local women have unique ways for caring for everyone, including children, and in particular girls, as the UN Resolution 1325 emphasizes. Speaking as a Ghanaian in Africa, although Ghana had experienced inter-ethnic conflicts, currently there is a peaceful environment. Other African countries, including Rwanda, Kenya, South Africa, Liberia, Cote d'Ivoire, Togo, Burkina Faso, Sierra Leone, and Guinea-Bissau have rather experienced intense conflicts far beyond independence. These conflicts have resulted in people experiencing poverty, trauma, and violence. The UN Platform for Action describes how girls and women are affected by armed conflict because of their unequal status in society and their sexuality. Among the most traumatic of these conflict effects are gender-based violence, sexual exploitation, stress, depression, hunger, poverty, rape, teenage pregnancy, sexual companions, girls recruited as child soldiers, they experiencing deteriorated reproductive health, and are exposed to harsh weather conditions. For instance, during the Rwanda genocide, it is estimated that between 250,000 and 500,000 women and girls were exposed to some form of gender-based violence. You can also cite examples of Sudanese local women with their children being displaced by the Janjaweed militia They drove them from their villages for them to settle in Darfur refugee camp. During the Liberian civil wars, about 12,000 refugees, including girls, with their parents fled the country, and most of them settled in Ghana. It must be noted that the United Nations High Commissioner for Refugees in 1990 established a refugee camp in Ghana, popularly known as Budumburam Camp, to settle these refugees. The camp also served the refugees from Sierra Leone who escaped from their civil war. As noted, it is becoming more common that women and children are always at the receiving end of every conflict and violence. As a result of these gender-specific effects, there is the need for local women to be on board to build peace and protect girls, because many local women are not included in peace building. The United Nations estimated that between 1990 and 2017, women only constituted 2% of conflict mediators and 8% of peace negotiators globally. As a result of low representation of women in the peace negotiations, 50% of peace agreements fail within their first decade. It is therefore encouraged that countries have local women as part of building peace to avoid the re-emergence of conflicts. For instance, in Rwanda, women represent 45% of the total community mediators, and their contributions after the genocide and civil war in 1994 were evidence. They participated in peace activism and advocacy. They became peacekeepers and relief aid workers. They served as mediators, worked as policymakers and educators, and they led other women in the socioeconomic development. Old Rwandese women are respected in society, just like men, and they are regarded as persons of integrity who are used to resolve conflicts. The Gashasha Rwanda is a traditional court which is headed by women. This traditional court cared for genocide survivors. They provided shelter for orphans, pregnant teenagers, and helped former female combatants to reintegrate into the society. Let's take Kenya, for instance. After the 1991 violent conflicts in Vajal in northern Kenya along the Somali border, these market women established Vajal Peace and Development Committee, which played prominent roles in building peace and measures to ensure the nation returned to peace. Again, a mother of 5 who lost her husband to post-election violence in Kenya brought together widows from all ethnic communities to pick up tensions in the communities early on and to promote benefits of peace for the community. These women use their social roles and networks to foster peace by initiating inter-ethnic dialogue in divided communities. Looking at Ivory Coast, the Ministry of Family, Women and Social Affairs led the development of National Action Plan in 2008 for the period between 2008 to 2012, which focuses on sexual violence against women and girls, and then subsequent legal protection of women and girls. Let's look at Liberia. As part of Liberian women's efforts towards peace building in Liberia, they advocated for ceasefire by embarking on mass action for peace. With this, the women barricaded the entrance of the venue of the peace talks to prevent the participants from walking out. Their actions were to maintain the negotiations in the event of dialogues getting heated up. In Burundi, pressure from women's organizations such as Women's Association for Peace and Women's Network for Peace and Nonviolence contributed to a culture of workshops on nonviolent conflict negotiation for national peace. So, what happens when women are involved? Reports on women involvement in conflict resolutions indicate that periods of transition offered a unique window to break the cycle of women's marginalization and make significant gains in women's participation in decision-making processes. In particular, the female gender in Rwanda stands out as active participants in governance. They occupy about 64% of the national legislature, and they are passing laws to end discrimination. Also, there is the establishment of preventive policies and actions which could empower women economically. In some countries, laws have been passed to eliminate discrimination against women and girls to protect their rights.
Okay.
Sorry,
again.
The net was bad.
No
yes,
problem.
I'll continue. Yeah, students have shown, studies have shown that with women's involvement, there had been an increase in girls' enrollment in schools from 5,000 in 2001 to 2.7 million in 2011. At the Bujumburan camp in Ghana, the Caroline Miller Elementary School provides free education to nearly 500 children in the camp. You see, the Security Council reported in 2012 that have indicated that having men and women in peace building was ultimately linked to gender equality. So we need to invest in local women's peace initiatives and indigenous processes for conflict resolution. Research on local women's roles in peace building and resolution will expose them to the public space and politics. It will also facilitate the enactment of any form of affirmative action bill to allow more women in public decision-making in African patriarchal societies. In conclusion, to emphasize what then Deputy Secretary General Jean Liaison said at the Security Council meeting in 2012, decisions made around this table are tangible if affect the lives of women and girls. So many local women, irrespective of their educational levels, should be massively involved in peace building and negotiations. Thank you.
Thanks to you, Dr. Janet Boateng. And we will, of course, pick up your last recommendations to involve local women to address conflicts and protect and support girls. This was a very enjoyable presentation on the African experiences and the role of traditional institutions there. So thank you very much again. And with that, I think that we exhausted the list of speakers of this panel roundtable because both Professor Sulafa Al-Shaalan from Al-Qadisiyah University of Iraq and Kito Masamengo were unable to connect. So at that point, I declare closed this roundtable. And I give the floor for the report on the activity and the proposals from the network to the next group of speakers. And I think I should address specific Dr. Giovanna Agnelli Landini. Am I true? Yes.
Thank you, Professor.
Thank you. Thank you.
Thank you, Professor Marchisio. Dear professors, dear colleagues, dear all, Monday's conference and today's conference mark two important moments of this entire week dedicated to the rights of children, especially girl children involved in armed conflicts. A week during which each university and institutions part of the network carried out initiatives on this issue in the context of its academic and research activities. The initiatives carried out have been numerous and of a very high level. Roundtables, lessons, part of the academic curricula, panel discussions, lectures, initiatives carried out both in the context of bachelor degrees and master's degrees, but also of doctoral courses and specialization courses, with the full and active involvement of all the participants. It is precisely in line with the spirit that is guiding the work of this network, namely that of cooperation and the sharing of point of views among all who are involved in these important initiatives, through in-depth analysis, research analysis, and awareness raising. Now, I would like to give the floor to my colleague, Simona Lanzellotto, who will give us additional information about the activities carried out by the participants in the network during this week. Please, Simona, the video is yours.
Thank you, Joanna. Thank you all. Yes, many universities of the network have been proposing many initiatives on the issue of children in armed conflict during this week, and many others are planning to organize seminars, lectures, masters, and so on the same issue. For instance, the University of Milan, in collaboration with the International Institute of Humanitarian Law of Sanremo, proposed a lecture entitled Children in Armed Conflict, 20 Years from the Optional Protocol to the Convention on the Rights of the Child. At the John Cabot University, the course Human Trafficking and Contemporary Slavery organized its syllabus focusing on two issues. Children in armed conflict and child soldiers, and the other one on peacekeeping and human trafficking. The Al-Alamein Institute in Iraq, in collaboration with the University of Perugia, has organized a series of lectures for postgraduate students, in particular the seminar entitled How the Law Deals with Children Recruitment, a review of the rules of international humanitarian law on this topic. The University of Pristina and the University of Regensburg decided to include the topic in their joint weekend intensive seminar. They wanted to raise awareness by asking the students to jointly research the topic in relation to Kosovo and Sudan. The University of Regensburg, in addition, decided to include the topic in the master's class Intercultural Communication in preparation for a role play among its students. The University of Perugia also organized a series of lectures on the Convention on the Rights of the Child and on its additional protocol. The Sapienza University is providing for the organization of a detailed study of the volume of Nicola Colacino on the exploitation and sexual abuses during peace operations. The University of Genoa also organized lectures on the topic with the involvement of many departments of the university and many professors. So all these initiatives and all the ones that are planned by other universities of the network will be collected in our final report that we will be doing at the end of the week. So thank you so much. And now I give the floor to my colleague, Laura Guercio. Thank you.
Thank you, Simona. But I think that before me, also Professor Anna Maria Ruffino wanted to take the floor. So if Anna Maria Ruffino is connected, I would like to give her floor. Yes, thank you.
Just a moment, please.
Yes.
Just a moment. Okay.
Yes, we
But
can listen you.
I speak French.
Of course, no problem.
Ok. Bonjour à tous. Juste 2 minutes pour collaborer à la discussion d'aujourd'hui. Considérant surtout les cas et la situation de divers pays dont nous avons entendu la description aujourd'hui. Par conséquent, je veux proposer quelques réflexions supplémentaires sur ce qui a été dit lors de l'autre réunion. Le caractère macroscopique du phénomène nécessite l'activation d'initiatives transversales. Les enfants, les jeunes filles impliquées dans les conflits, dans les événements de guerre sont une partie active de ces conflits. Et une partie active doit être dans les actions que nous programmerons. De même qu'ils sont traçables en fonction de la succession des phénomènes dramatiques et de guerre, il faut les rendre activement traçables dans des initiatives contrastées, notamment par des actions de formation, de rééducation et de socialisation. La destruction d'espaces de vie de tous les sens, dans tous les sens, l'absence de toute forme de services et d'aide, la destruction des milieux familiaux et affectifs, le déni de tous les types de ressources peuvent être repensés en fournissant un tissu humain, avoir éducative, de formation relationnelle, de manière à contrebalancer les préjudices subis également sur le plan formatique, psychologique et émotionnel. Et résumer encore brièvement, encore une fois, l'étape possible à réaliser. 1. Sensibiliser la communauté scientifique et la société civile. 2. La création de groupes de travail ministériels, interministériels et surtout universitaires avec la collaboration des États. 3. La création d'outils de diffusion d'informations sur les sujets, de sensibilisation des citoyennes, d'implication des institutions locales. Et 4, la plus importante, la possibilité de créer des modèles opérationnels sur place et ici, pour l'éducation, la socialisation, y compris affective, pour la formation ludique, sexuelle, créative, linguistique et communicative. Mais les données doivent être observées dans leur complexité. En ce sens, opérer à travers la cartographie des territoires, l'identification des criticités les plus émergentes pour mesurer l'impact des phénomènes et agir sur la front communicative de manière transversale et efficace. Je vais m'arrêter ici pour aujourd'hui, mais au travail pour tout. Merci beaucoup.
Thank you, Professor Rufino. Thank you very much for your very interesting comments. I would like also to add another suggestion that I've just received from Professor Cilea. Professor Cilea could not remain with us, but he asked me to announce his proposal to involve the university's network in trainings placed in different cities and targeted to lawyers for victims before the ICC. I think that it is a very concrete suggestion on which we can work. And now I would like to give the floor to my colleague, Deborah Capalbo. She worked a lot with all my colleagues for the organization of these two conferences. And please, Deborah, the floor is yours.
Thank you, Laura. Thank you, all the speakers. And I now give some points about the proposal that we received from the universities which have joined the network. In fact, the network has asked the joining university to think and to provide some proposals aimed at cooperating in our work. Basically, a work of research on protection of children and girl children in armed conflict. As Professor Marchiso has mentioned in the beginning, the United Nations Convention of the Rights of Child, the CRC, that was adopted on this very date 31 years ago, has provided a revolutionary approach based on the fact that the children are beneficiary, are subject of rights, and not only subject of protection. So this means that they have their own opinions, they have their own views, and these need to be respected. Bearing in mind this, we need to consider that this situation are valid in a peace situation, but also in a situation of conflict, much more in situation of conflict. So briefly, the joining universities have suggested basically two kinds of proposal. The first is to think how to strengthen the already existing legal instruments for protection, for prevention and reintegration of children affected on the one hand and involved directly and indirectly in armed conflict. On the other hand, the universities proposed to establish specific research groups with the aim of strengthening the multidisciplinary nature of the network. And I'd like to underline this point because the network has universities not only from legal background, but from many faculties. And we will provide more precisely with the proposals in the coming days. So I will give the floor now back to my colleague Laura Huercho. Thank you for the attention.
Thank you, Deborah. Thank you. We are at the conclusion now of the two conferences of 16th and 20th November of today, during which we have collected many suggestions, informations, and comments from the universities of the network. The purpose of these meetings was right to reflect all together on what to do on the topic of children in armed conflict and how to do it. And I think that it's very important that a suggestion came from professor and department working on different disciplines. In fact, the network is made up of universities dealing with different disciplines, and this is a very, very important aspect. I would like to ask Professor Federici how much is academic multidisciplinarity important for an effective work on the issue of children in armed conflict. Please, Professor Federici, may I ask you to take the floor?
Yes. I am.
In French, if you want.
Yes, I am.
En français.
OK. Un hommage à la différenciation culturelle de beaucoup des universités africaines et de l'Asie, en français, oui. Alors, l'approche interdisciplinaire est inévitable et nécessaire. Et il y a un problème de méthode, et je l'ai souligné dans les séminaires de lundi passé. Il est aussi très important la comparaison interculturelle. Et beaucoup des interventions, il a souligné cet aspect, mais je suis très content de pouvoir encore souligner cet aspect qui sont la chiffre d'une analyse, de recherche, des études qui vont caractériser les networks. Après, je dirais quelque chose aussi sur la structuration de les networks. C'est très important pour travailler en faisant très rapide. Alors, la comparaison interculturelle, c'est important aussi comme la spécificité culturelle. Nous avons écouté beaucoup de contributions de beaucoup de sièges universitaires qui viennent de territoires très différents et qu'il a mis en place et qu'il a nous donné beaucoup de différences. Il y a des chiffres communs. Il y a sûrement la violence, il y a sûrement la famille, il y a sûrement la formation qui sont des choses inéludibles. Mais les deux séminaires, aujourd'hui, il a renforcé, mais les deux séminaires, il a mis en évidence la nécessité d'analyser, d'étudier et de faire recherche sur différents plans. Alors, je vais faire un résumé très rapide des choses qu'il a notées en écoutant toutes les interventions très intéressantes et je remercie beaucoup les sièges qu'il a participé à cette ces deux séminaires qui l'ont permis d'avoir un panorama très ouvert, très précis, très spécialisé de quelles nous attend, des choses qui nous attendent et des choses à lesquelles nous devons être préparés à faire. Alors, il y a les différents plans, ils sont le plan social. Le plan social, il y a le plan familial, il y a le plan culturel, il y a aussi le plan religieux, qui n'est pas indifférent. Il y a un plan sanitaire. Beaucoup des interventions, il a mis en évidence la violence, qui est une violence physique, qui est une violence sexuelle. Et nous avons l'évidence, la constatabilité de cette chose. La violence sexuelle et la violence physique, c'est un chiffre de les enfants, des enfants féminins surtout. Pas seulement dans les zones de conflit ou de guerre. Hein. Il y a une chose culturelle, une chose familiale, une chose supportée sans les normes qui peuvent garantir que ça ne passe pas. Donc, il y a un plan sanitaire qui va permettre l'acquisition de bien-être. Parce que cette jeune fille, cet enfant, il doit être sécurisé, il doit être soigné, il doit être mis en place de leur jeunesse avec la formation, la santé et la sûreté. Et aussi, il y a un plan normatif, les lois. Les lois, elles sont très différentes. Les lois de notre pays du nord de planète, les lois de nos pays développés, ils sont très différentes d'autres pays. Il y a un plan de la formation qui lie tous les plans précédents parce qu'il est nécessaire d'assurer à cette jeune enfant, à cette fille, la formation. La formation, il développe économiquement aussi. La Banque mondiale il a démontré qu'avec de petits crédits à les jeunes femmes des zones les plus difficiles de la planète, il se développe un grand réseau économique. Il change beaucoup la famille, il change beaucoup la perception de la santé, il change tous. Donc, il est très important le plan formatif. Assurer la formation, assurer la santé, assurer la liberté à travers les lois. Comment faire ça? Ça, c'est le problème. Nous avons écouté beaucoup de choses importantes, beaucoup de choses très suggestives, beaucoup de choses sur lesquelles on demande de travailler, de faire recherche, de mettre en place nos compétences. Mais je crois que notre network, elle doit développer quelque chose utile qui soit utile de travail, un utile qui rendre plus facile de travailler, de se rapporter et de faire les choses qu'ils nous sont appelés à faire. Donc, je vous propose de réfléchir sur la méthode d'un consortium entre les sièges qui sont disponibles et qui ont les outils normatifs, parce qu'il y aura quelques problèmes, je crois, de faire un consortium entre les sièges qu'il a fait chef à les networks, structurer ces consortiums avec un conseiller scientifique, un conseiller directif, avec un grand président qui soit une figure de représentation et de garantie pour les études et pour l'analyse et pour la recherche et pour la présentation de cet produit, de notre travail à l'extérieur, parce que c'est important ça. Garantit la scientificité, garantit la représentation de ce que nous allons faire. Donc, je vous recommande, je vous donne à penser, si vous voulez, cet plan des interventions. Et là, je m'appelle surtout à les collègues qui s'occupent des droits, qui s'occupent des choses législatives, d'étudier avant tous la forme à donner à cette network. Nous sommes disponibles, nous sommes à disposition pour tous les networks que vous avez. Et cette forme, il permettra de faire un travail d'excellence. Et je crois que nous avons démontré dans ces deux séminaires qu'il y a toutes les possibilités de faire un travail d'excellence. Merci.
Thank you, Professor Federici. You have introduced just a very important aspect, because now we are 30, the network counts 38 universities and research centers, and we have to think about how we want, how about the structure we would like to have. So for this reason, I would like to give the floor to Professor Poccar, and asking him what structure could we propose to our colleagues to make our work effective, and what's our next work. Professor Federici already introduced this issue, but I would like to give Professor Poccar also the floor. Please, Professor Poccar.
Thank you, Laura. My colleague, Professor Federici, has already dealt with almost all the points on this, and I can certainly agree with her on a sort of structure that might help other work. This network, these conferences in particular, have shown that a number of topics should be addressed if we want really to contribute to the promotion of the protection of children in armed conflicts. We focus particularly on girl children, but of course there are children as a whole also to be dealt with, and we need to see how to proceed in helping that. Let me recall that at the beginning, both the Vice Minister of Foreign Affairs of Italy and even more the representative of the security of the United Nations on children in armed conflicts have underlined that action has been taken, many actions have been taken in this matter, but what was lacking actually was the academic research and support, which makes this network particularly timely. But to be able to contribute and give a real contribution also to the institutions that work on the field, that have a wider approach in dealing with these matters, like in particular the United Nations, of course, I believe that that we have to become a sort of partner in a way to help the United Nations, particularly the rapporteur in this case, but there will be other partners, because the rapporteur herself has mentioned a working group where she is in a way the secretary, but this working group has a wider scope of activity clearly than the special representative as such. That means that this is a real matter of concern for the United Nations, and we have to not to take up all the activity of the United Nations, this matter, of course, we cannot as universities, but to be the, say, the pillar that is represented by the academic work and research work. May I say, Laura, you will allow me to say that these conferences have been, and the network so far, had a sort of coordination, so-called committee, where, Laura, you were actually the person representing everything. You have kept the contacts with the members of the network. You have organized the work. With you, I have to mention the group of young people or professionals that have worked with you and worked pro bono, of course, as you worked pro bono. Now, other people have worked. I mean, some professors, Professor Marchisio, myself, Professor Federici, have also worked with you. But the center of the activity were you. I believe we cannot go on simply on that, say, as amateurs. You have worked as an amateur that works on the topic, and they've done a wonderful work in this organizing these conferences with your team. But we
don't make me shy, please.
no, well, but this is the reality. I say what happened. Actually, I'm just recording what happened.
Thank you so much.
I think we have to put in place a structured, a more structured organization, association, like the one that Maria Caterina Federici has mentioned. We have to look at it and see what we can do. Can be under Italian law, could be a consortium of universities that can encompass foreign universities as well, of course, and as well as research centers, having as a topic the children in armed conflicts. It looks a small topic, actually, but our conferences have shown it's a very wide one. It's a big topic because we couldn't exhaust any of the issues that was raised during this conference. No speaker was able to deal with everything, would have more to do, and discussants would have to give even more participation. So my feeling is that if we work, we have a lot of work to do, actually. And Maria Caterina has already mentioned the multidisciplinarity of the work, the need to coordinate all this. I don't mean we should have a very heavy structure. This is not this is not the idea, but a structure that coordinates, and the coordinating committee having the trust of all the entities that participate in the network, I think is needed. Of course, it's clear that all the entities, university and research centers, will be able to do their work as they wish. This is clear. They're in full freedom. But there are activities in which we can work together. And when we work together, we should coordinate that work as much as possible. So perhaps the idea is to launch the sort of association that could be also a partner for the United Nations in a way of the academic on the academic side, and launch that with a document that could be a sort of statutes, and see whether all the universities that participated in this endeavor up to now wish to participate in such a more structured form to our work. And this could be the idea. We could make a proposal. I mean, or those who up to now worked on this, probably taking advantage of the relationships that you have already built, Laura, and of course you will be again the center to transmit this, to interact with all our partners in order to see, and of course they can make on a draft that we can circulate, can make any change they wish to change. I mean, I don't think it should be imposed anything on anybody in this matter. We are a voluntary group that wants to work on this important and very, very important topic. There is the, it has been mentioned that some university advanced the idea, put forward the idea of improving the legal instruments we have. We have the protocol, we have the convention, of course, on the rights of the child. The protocol can be probably improved in some regard. And there are other documents can be improved, other legal documents. There should be something for lawyers, of course, at the end, but what the lawyers should propose technically should come from also the other disciplines, of course, because the changes in the law should reflect the needs that are felt in any. And then we can work by working groups, maybe coordinated working groups, in order that if there is working group on a specific topic, should gather the people that want to work on that working group. And there is no need to make a second working group on the same topic. I mean, if we work randomly as we are now, we risk to make the same work each. And I don't think that is very productive. We should work together and coordinate the researches that we make. And that should be the future I see to this. And perhaps in the future, we will have different conferences, not of the same kind, because now we wanted to have possibly all the 38 entities getting together and know each other, also talk to each other in a conference, each giving a view of what they are doing. But later, when we have working groups on specific topics, we may have conferences on specific issues also, in order to improve the situation in a specific area, and not necessarily put everything together, but have the time in a conference to have good and exhaustive presentations, and on that a really good discussion that may lead to even to recommendations to the United Nations, or be taken up by the United Nations in their work on, and other units, their work on children. This will be my approach.
Thank you so much, Professor Poccar. You immediately supported this network, and you are a very important referent for us, as of course Professor Marchisio and Professor Federici. You mentioned me, but I would like to thank Deborah Capalbo, Simona Lancellotti, Giovanna Agnelli. It could not be possible to do what we have done until now if we didn't work together, all together. Only working together, we can restore hope to these most vulnerable of all children. And that's the message that Ms. Gamba said on the conference held last November 16. Over the years, she said that the international community has tapped on many different resources to make things happen for children, but it has never applied its intellectual power to this end. Your network, our network, all together can be the force multiplier the international community needs to ensure that children are no longer used and abused by, in, and for armed conflict. So we have to work a lot, but I do hope that we continue on this field to collaborate together, and surely we will submit in the next days an idea of structure we could adopt all together. Before concluding, I would like also to thank Sergio Iovino. He is the author of the beautiful video we have seen before, and also the author of the music. And he is with us today, but sorry, they are saying me that also Professor, I'm not sure, but probably Professor Musimango is with us. Massimango, if Simona could, Simona, can you confirm that Professor Massimango is with us?
Yes, he's connected.
If Professor Massimango, if you are connected, I would like to give you the floor with deep pleasure.
Oui, je suis en ligne. Bonjour.
Yeah, we can listen you.
Bonjour Laura.
Hi, bonjour ou bonsoir.
Ah oui, bonsoir. Ici chez nous, nous avons la même ère avec vous actuellement.
Oui.
Oui. Je salue. Je peux intervenir maintenant?
Oui, bien sûr.
Merci. Je suis encouragé par l'organisation de cette conférence interuniversitaire qui traite des questions pertinentes et d'actualité par rapport aux grands problèmes qui touchent la société mondiale actuellement, en particulier la question liée aux personnes les plus vulnérables, dont les enfants et les femmes. Et là, je voudrais, dans quelques minutes qui nous ont été imparties, de partager avec les participants sur les efforts de la mise en application de la résolution 1325 en République démocratique du Congo. La République démocratique du Congo a pris des dispositions à adhérer à cette résolution importante des Nations Unies 2 ans après son adoption par les Nations Unies. En d'autres termes, c'est depuis 2002 que la République démocratique du Congo a adhéré à cette résolution. Et pour matérialiser ses engagements en rapport avec son adhésion à la résolution 1325, 10 ans après, en 2010, la République démocratique du Congo a mis en place un plan national pour la mise en application de la résolution 1325. Et ce plan national, qui a été axé sur 12 points importants, a prouvé l'engagement de la République démocratique du Congo, donc du gouvernement, à augmenter la participation de la femme à la prise de décision sur la paix et la sécurité, mais également le gouvernement a
I think there is a problem with
l'engagement à prendre des lois, à améliorer le cadre législatif par rapport au 15. Oui, allez, vous me suivez? C'est ainsi sinon d'une première loi qui a statué sur la parité, et cette loi a disposé de la participation de la femme dans toutes les institutions de la prise de décision à un CMP de 30%. Oui?
No,
Vous me suivez?
there was a problem. Now it's okay. There was a problem
Hello?
with the audio. Yeah, you can go on. You can continue.
Allô?
Allô?
Oui.
Allô?
Allô?
Tito?
Oui, je vous capte, vous me suivez?
Oui, oui.
Oui, alors, j'étais en train de dire par rapport aux avancées législatives qu'on a enregistrées à la République démocratique du Congo, c'est à ce chapitre que j'étais déjà, comment la République démocratique du Congo a amélioré le cadre législatif par rapport à la résolution 1325. Et là, je voudrais signaler que depuis la période coloniale, il n'y a jamais eu une loi qui était en faveur de la participation de la femme dans les différentes instances de la prise de décision. Et c'est en 2015 que nous avons la première loi sur les modalités de la mise en application de la résolution 1325. Et cette loi a aidé la République à augmenter la participation de la femme dans les différentes institutions de prise de décision. Mais également, cette loi a démontré l'engagement du gouvernement à améliorer les conditions de la femme qui se retrouve dans des différentes situations et en particulier dans les milieux où il y a les conflits armés. Et comme la République démocratique du Congo, de par notre constitution, la loi nationale dispose d'un monisme constitutionnel. Et en dehors de cette loi de 2015, il faudra ajouter les différents traités, conventions et accords, les lois internationales qui ont été ratifiées par la République démocratique du Congo. Et ainsi, vous en avez tout ce que vous connaissez en cette matière, la Déclaration universelle des droits de l'homme.
I think we have problems with the connection. Simona, I cannot. Hello?
I think he's.
Là, ce sont les efforts législatifs.
Yeah, okay.
Allô?
Oui, oui.
Yeah.
Oui. Alors, sur le plan pratique, c'est là où ça se pose maintenant un problème qui réside, bien qu'on a un cadre législatif qui est clairement défini.
I think we have problems with our friends Quito with
Et
connection.
nous n'en avons que 13 femmes. Il y a des efforts à fournir, donc les caps de 30% au moins qui se trouvent prévus pour la participation de la femme, il n'y en a pas. Et lorsque nous regardons le Sénat qui a 8 sénateurs, et au niveau du Sénat, nous n'avons que 23 femmes. C'est encore un pourcentage assez faible. Et au niveau de l'Assemblée nationale, sur 500 députés, nous n'avons que 65 femmes. Le pourcentage est encore assez faible par rapport à la participation de la femme dans les institutions de prise de décision. Mais il est à signaler que nous encourageons quand même au niveau de l'Assemblée nationale. Depuis l'histoire du pays, c'est pour la première fois que nous avons une femme qui a été élue présidente de l'Assemblée nationale, en la personne de Madame Honorable Janine Mabunda. C'est la première femme qui occupe cette haute fonction depuis que la République démocratique du Congo existe, depuis le temps colonial et jusqu'après l'indépendance. Ça, c'est quelque chose du moins qui encourage les femmes dans le cadre de la mise en œuvre du moins de la résolution 1325. Mais à ce chapitre, il faudra souligner maintenant les défis qui sont importants. Il y a les défis qui se retrouvent avec tout ce que la République démocratique du Congo vit, des cycles en succession de conflits armés, de guerres interminables depuis plus de 3 décennies. La République se retrouve dans des guerres. Eh bien, la participation de la femme est vraiment faible. Et la première victime dans le rang de ces conflits, il n'y a que la femme. Les hommes prennent des dispositions pour faire la guerre, mais pour trouver des solutions à ces problèmes, la femme n'est pas suffisamment associée. Eh bien, nous pensons qu'il y a à cela beaucoup de causes, entre autres, la vulgarisation, le problème de la vulgarisation de la résolution 1325 qui pose le problème. La République démocratique du Congo n'a pas une technologie avancée actuellement, comme ça se passe en Europe et ailleurs. Et donc là, il faudra multiplier de bonnes stratégies pour la vulgarisation de cette résolution qui n'est pas connue à ville qui s'approprie cette résolution. Mais également, il faudra fournir des efforts pour mettre fin à la guerre, puisque d'un côté, il y a les gouvernants, les autres institutions disent que voilà, il faudra la situation de guerre puisse d'abord prendre fin pour qu'on puisse voir maintenant comment renforcer la participation de la femme dans les institutions. On ne peut pas envoyer les femmes dans certains milieux où se trouve la guerre au regard de leurs conditions plus vulnérables, et ainsi de suite. Et là, ça demande le concours de la communauté internationale, puisque comme nous le savons, La plupart des groupes armés qui se retrouvent à l'est de la République démocratique du Congo en particulier sont soutenus et créés par des multinationales qui viennent exploiter les richesses de la République démocratique du Congo sans contrôle, en toute irrégularité. Alors, il faudrait que la communauté internationale puisse se mobiliser pour mettre fin à tous ces conflits armés qui se passent, qui se succèdent à la République démocratique du Congo. Et comme ça, nous pouvons relancer une autre vision par rapport à la participation de la femme dans les différents processus pour le développement et en particulier dans le cadre de la matérialisation des objectifs des millénaires pour le développement. Et voilà, je voudrais m'arrêter à ce niveau-là par rapport au temps qui nous a été imparti. Et peut-être avec les échanges, nous pouvons toutefois y revenir pour donner un autre élément pour consolider ce que nous venons de dire. Merci bien.
Merci, Kito. Merci, Professor Massimango. Of course, we will have other occasions to work together and to share all the documents that we can collect from the different universities. And we are very glad that you could join us. And also thank you for giving us this important information about your country. Before concluding, I would like also to thank all the universities, all professors, all the department that join us, and they were fantastic. Please allow me to say that it was so great to work with you all, and I'm sure that we can work on very important issues, research. We, as Professor Poccar said before, we can organize different working groups, different areas on which we can work. So we have a lot to work together, but together, as Ms. Gamba said, we can restore hope to children in armed conflict. And now I would like to conclude giving the floor to Sergio Iovino. As I was saying before, he is the author of the video and also of the music, of the beautiful video and music we have listened and we have seen before. And I would like to give him the floor. Sergio, are you with us?
Yes.
Yes, so the floor is yours.
Thank you, Laura. Thank you, Laura.
Thank you, thank you. Please, I would like, if you may, just to give us some information about your video and your song. Why did you choose did you want to collect all that picture, and why? What is the meaning of the words in your music, in your song, please?
Okay, thank you. I would like to really thank the Università Network for Children in Armed Conflict for giving the important opportunity to care about the artist part of the project. I was honored to realize the song Let Them Play with Their Dreams, which I hope will have a magic impact on the heart of millions of students and people all around the world. Let Them Play with Their Dreams is the first song on the global scenario to represent by means and poetry and aphorism the 6 grave violations and against children identified by United Nations. For instance, the violation of recruitment for children is symbolized by dress and rage and cruelty, referring to children dressed with military uniform and shotguns. In the Sky, the Heron Line will deliver relief to your heart, part of the chorus of the song, refers to the violation of denial of humanitarian access for children and to the importance to guarantee to children humanitarian assistance. We will write your future on a blackboard, symbolize the need to guarantee education also during armed conflicts, as the best instrument to permit children to hope for a better future. Each violation is represented in the video also by a specific imaging. Together with the Italian Minister of Foreign Affairs and International Cooperation, which contributed to this unique artist project. We hope to spread the video in all international relevant fora, with a view to raising awareness to the general public at all levels. Artist communication is often the best way to deliver an important political message to the international general public all around the world. I really hope this will be the case. I thank you all for your attention. Thank you.
Thank you, Sergio. And allow me to thank the Italian Ministry of Foreign Affairs International Cooperation for the deep support that it gave us until now, and it's our pleasure to collaborate with the Italian Ministry of Foreign Affairs also for future ideas that the network wants to carry on. And now I think that we are at the end, but not at the end, we are just at the beginning. So we had the chance to know each other. I would like also to say that other universities join us during this week. So now we are 38, and we are a large number, and for this reason we surely can do a very great job. So thank you so much for you all, and for everything. We will be in touch, we will keep in touch. And now I think that the best way to conclude is just to listen and to see the video from Sergio Iovino. Thank you so much.
Little souls with eyes so fragile, who dream of living in a colorful world, suspended in the uncertainty of tomorrow, wounded by an incomprehensible world, dressed in rage and cruelty. Then it's time to join us all. Take our hand, don't be afraid anymore. In the sky, the hand of light will deliver a link to your heart. We will write your future on a blackboard. We will take care of your wounds. We are your present, you will be our future. Little souls, now you are safe. Dark souls, guilty of an incomprehensible world, or interrupt their sleep, injury their pureness, turn them away for home. Let them play with their dreams, so that when they finish sleeping, they will not be afraid to open their eyes. Then it's time to join us all. Take our hand, don't be afraid anymore. In the sky, the hand of light will deliver a link to your heart. We will write your future on a blackboard. We will take care of your wounds. We are your present, you will be our future.